order. Madam Secretary, please call the roll.
Senator Rocky Adams. Senator Chambers Armstrong. Senator Herron. Here. Senator Maiden. Here. Senator Mays Bledsoe. Here. Senator McDaniel. Here. Senator Mills. Senator Rawlings. Here. Senator Tishner. Vice Chair Elkins.
Present.
Chair Nemus.
Present. We have quorum, so we're... Okay, please remember to silence your cell phones and turn on your microphones when you need to do so. We're going to go out of order from the agenda. The first item on the agenda is going to be Senate Bill 132, sponsored by Senator Funky Fromeyer. Please introduce yourself and your guest, and the floor is yours.
Thank you, Chair Nemus, and thank you for adjusting the schedule. My name is Senator Shelley Funky Fromeyer, and I represent Campbell, Pendleton, Bracken, and the northeast corner of Kenton in the Covington area.
My name's Chief Brian Taylor. I'm the Chief of Police at the Lawrenceburg Police Department in Lawrenceburg.
He said speak up.
My name's Brian Taylor. I'm the Chief of Police over in Lawrenceburg, right next door.
And I'm Gracie Kelly with the Kentucky League of Cities.
Thank you, committee, as well, for reviewing this. Senate Bill 132 is to address growing concerns that our city and some of our officials in the community, but also community members, recognizing something's not right. And they're trying to better understand what might be wrong. And in this particular situation, was recognized in a massage parlor. And you would be hopeful that a massage parlor is offering massages. But recognized by this young lady and brought to my attention during a human trafficking conference that was just a small gathering at one of our churches in Alexandria. And one of the community members came up to me afterwards and shared some photos of a few advertised massage parlors and spoke a bit about activity that she observed, and then an opportunity to visit some young ladies that are offering massages, and fairly quickly recognized that these young ladies look underage, and they don't necessarily look like they would have grown up in our community. But fairly quickly, after bringing it to the attention of the local authorities, it appeared that there wasn't real clear processes that the city officials or the law enforcement could take. So until it was brought to my attention, and we brought the Attorney General's office and a few other important people to the issue, the massage parlor disappeared within about 3 days. But where did they go? So Senate Bill 132 is trying to address that if this business is a legitimate massage therapy establishment, well, the current law does have some interpretation, but it limits the local government's ability to regulate their operations. It's making it more difficult for local governments to respond to these complaints and perhaps better protect our public safety. So Section 1 of Senate Bill 132 clarifies that nothing in state law limits a local government's authority to regulate the operation of a business that are to be owned or claimed or operated or affiliated with licensed massage therapists. The bill expressly authorizes cities to adopt and enforce ordinances related to zoning, local business, or occupational licensing requirements and standards, occupational license fees, inspections, advertising, hours of operation, and sanitation requirements. This clarification ensures local governments can more effectively investigate complaints and address illegal activity at businesses representing themselves as massage parlors, while leaving regulation of the practice of massage therapy itself with the state. Section 2 strengthens enforcement of massage therapy licensing requirements by increasing the penalty for violations of the statutory requirement to have a license to practice massage therapy or use titles, advertisements, or signs indicating the provision of massage therapy from a Class B misdemeanor to a Class A misdemeanor, and making each unlicensed massage therapy session a separate offense. This change reflects the seriousness of operating without a license and aligns massage therapy enforcement with other professionals requiring close personal contact. Importantly, existing affirmative defenses remain in place, including protections for victims of human trafficking. In summary, Senate Bill 132 provides clarity. It restores appropriate local authority, and it strengthens enforcement tools, and it really does help close that gap around illegal activity. Thank you, Mr. Chairman.
Thank you, Mr. Chairman and members of the committee. Again, my name is Chief Brian Taylor at the Lawrenceburg Police Department, and I'm here today representing the Kentucky Associations of Chiefs of Police in support of Senate Bill 132. This bill gives law enforcement local governments the clarity we need to address potential illegal activity occurring at businesses often holding themselves as massage parlors. Right now, unclear authority can limit our ability to respond effectively to complaints and ongoing violations. Senate Bill 132 clearly affirms local authority to regulate these businesses through licensing, inspections, operating standards, and it strengthens enforcement by increasing the penalties for unlicensed massage therapy. Those tools are essential for addressing repeat offenders and protecting our communities. Importantly, as the Senator clarified and said, this bill maintains protections for victims of human trafficking and ensure enforcement on the bad actors and not the victims. For these reasons, the Kentucky Association of Chiefs of Police support Senate Bill 132. Thank you for your time today.
We have a motion and a second. I see no one asking for a question, so Madam, please call the roll.
Senator Rocky Adams. Senator Chambers Armstrong. Senator Elkins.
Aye.
Senator Herron. Senator Maiden. Senator Mays Bledsoe. Senator McDaniel. Senator Mills. Senator Rawlings. Senator Tishner.
May I explain my I vote?
Yes, please.
Thank you. This is a great bill. I love it. It's just simple. It's just one page to put some common sense measures in place to address an issue that's probably more prevalent than we realize and happening in every area of our state, whether it's in lower economic areas or higher economic areas. It's everywhere. So thank you for your work on this, Senator, and I'm happy to vote aye.
Chair Nemus.
Aye. Senate Bill 132 passes 9-0 and will passes with favorable expression, and we expect to do so on the floor. Thank you.
Thank you, Mr. Chairman. Thanks for making this a priority.
The next item on the agenda is Senate Bill 33, sponsored by Senator Thomas. Introduce yourself and go ahead.
Thank you, Mr. Chair, and thank you, members of the committee. My name is Reginald Thomas. I represent Senate District 13, which is self-contained within Fayette County. Okay, and the reason I am here today, I will begin by noting the work of Senator Julie Rocky Adams. In 2023, Senator Adams established a bill that created what we call recovery residence centers. What this bill does is that it provides for transitional housing for individuals who've had very bad substance abuse problems, who addiction issues, who want to work through that, and prior to them reaching, back to full community living, they transitioned to a center that still oversaw their treatment, provided them counseling, provided them job training, as a way to finally get them back into the community. That bill by Senator Adams passed in 2023, and then she tweaked it in 2024. Okay. As we all know, anytime you create some legislation that allows for something, you're going to have bad people come in and try to get around it. And what we've seen since the passage of Senator Adams' Act is places in my hometown of Lexington and in Louisville, Senator Herron certainly is aware of this, who have purportedly established these residences that have not complied with the certification requirements set forth in Senator Adams' statute. The current statute requires certification by the Kentucky Association of Recovery Residences. Well, what's happening now is that you have a number of fraudulent places purporting to be recovery residence centers, but they are not. They've not been certified. The result being is that you've had these places that have a lot of filth, on their yards, garbage, trash, cigarette butts. They're engaging in illicit activity that is, very degrading to the community, and just creating a situation because of these centers that have really deteriorated the community and caused really unsafe conditions within the neighborhoods. Well, my bill seeks to correct that. Okay, because what my bill does is says that if someone wants to establish a recovery residence center, go through the certification process, they must do certain things. One, within 30 days of application, they must notify the city that they are applying for a recovery residence center. And within 30 days after they receive that certification, they must notify the city of that. If there are any fines imposed upon them during their entire operation, they must notify the city of that within 30 days. And they must provide information like who's the owner, the name, address, and email address of the primary contact person, and the name, phone number, and address of the residents. In addition, my bill provides that the city may maintain a registry of all these recovery residence centers so that the city knows exactly who the registered certified recovery residence centers are and where they're located. That way, if they get information about a recovery residence center or a fraudulent one that's not acting properly, all they need to do is go to their registry, look up, get the address, and if that location is not on their registry as being a certified recovery residence center, they can go over there and seek to close it and shut it down, prevent that actor from happening. I will point out to you that I've made one significant change in this bill that's going to be done by a floor amendment. The bill as currently written provides that this information is going to be open to the public. Okay? I've been in contact with the Kentucky Association of Recovery Residence Centers. Mr. Prieston is here today. He's glad to come forward and talk to you. And I do agree that it's important to maintain, I can't emphasize this enough, it's important to maintain the non-public nature of the location of these recovery residence centers from public information. And I'm doing that because when this bill was initially passed, it was understood that a lot of these people come from very vulnerable populations. Again, they've been subject to addiction. They've been subject, in many cases, to domestic abuse. And we don't want people to come in and take advantage or potentially harm those persons who are really trying to get treated and return to society. So I've taken out under your bill paragraph G that talks about this being a public record on page 2, lines 4 to 6. That sentence is coming out. The paragraph 2, lines 8 and 9 is going to stay in. That will stay in. And in addition, on page 3, that last sentence on lines 21 to 23 is coming out as well, so that no one can have the ability to obtain, where these recovery residence centers are, except for the city itself. And that's all that needs to be done. That's all that's necessary, is that the city be aware who's a certified recovery residence center and who is not, so that those individuals, those residences and individuals behind them who want to take advantage of these people, who get Medicaid, receive money from them, and not comply with the certification process can be removed, and we can make sure our neighborhoods, can remain safe and satisfactory for our citizens. With that said, I have Mr. Dane Prieston here, who's with the Kentucky Association of Recovery Residences. He's here to testify if he wants to come forward. And
Yes,
other than
Mr.
that,
Prieston, state your name and
Good afternoon, Committee. Chair Nemus. My name is Dane Prieston. I'm the Executive Director of the Kentucky Alliance of Recovery Residences, the designated NAR affiliate for the state of Kentucky, and a recognized certifying organization by the Cabinet and Family Services.
you have a statement or you want to talk?
I do. Thank you very much. And thank you, Senator Thomas, for bringing this bill and your willingness to collaborate regarding the making of addresses public record. In Kentucky, over 70% of women entering recovery residences are been the previous victim of intimate partner abuse. And having these addresses be made public record would put them at risk. When these laws were initially fought for back in 2023, this legislature looked at whether or not addresses should be made public record and then specifically put in the statutes that they should only be released to law enforcement, local municipalities, and emergency services. I'm very grateful for Senator Thomas for collaborating with KIAR, us, on this bill. And we do support the remaining elements of it as in regards to cities being able to maintain a public registry or an internal registry of recovery residences, since our mission is to provide greater access to quality recovery housing and have cities have the ability to refer to those good actors, as Senator Thomas put it, those quality actors, and having that registry that they can then reach out to us about. And ask whether or not someone is certified, has met the NAR standard, which is a very rigorous process, which I'm more than happy to speak on much more great detail about. But we are more than willing to forge those relationships with municipalities we have been doing for the past few years.
Thank you very much. Okay, we have a motion and a second on the bill, but first I want to make this clear and succinct that what we're doing here. Senator Thomas is passing a bill that Mr. Prieston and that don't specifically like, with the assurance that he's going to have a floor amendment. And to get this through the committee, we didn't have a committee substitute because he didn't have time to do it according to my rules. But we have his assurance that we have a floor amendment coming to address Mr. Prieston's questions and concerns. So with that, Madam Secretary, please call the roll.
Senator Rocky Adams, Senator Chambers Armstrong, Senator Elkins, Senator Herron, Senator Maiden, Senator Mays Bledsoe, Senator McDaniel, Senator Mills, Senator Rawlings, Senator Tishner, Chair Nemus.
Aye. Senate Bill 33 passes 8-0 with favorable expression, and we expect to do so on the floor. Thank you, Senator Thomas. The next item on the agenda is Senate Bill 85, sponsored by Senator Webb. It's an act relating to designation of special needs trust to receive state-administered retirement benefits. Please introduce yourself and your guest and continue.
Thank you, Mr. Chairman. Senator Robin Webb, 18th District, and I'm proud to have my co-sponsor of the bill, Senator Carroll, with me. And for my technical assistance, I passed the bar, Senator Rollins, in spite of the trust question, and I brought my expert in, Tanner Duncan, who is a lawyer with Wyatt in Lexington, and it's a kind of a full circle for me because I've watched him grow up and been close to his family. So he showed an interest in this bill and made some tweaks to the bill from a trust lawyer standpoint, specialist standpoint, that made it better. And even though we passed this out of the Senate last year in its previous form, it's a better bill now, to quote my friend Representative Barbara Coulter. It's a good little bill. So Public Pension Oversight Board heard it last year and kind of waved it on to this committee this year, so we have their approval as well. And what this does, it requires our state retirement systems to acknowledge the fact that a state employee can make a special needs beneficiary create a trust to on their death for retirement benefits to go into that and provide some level of peace for those parents and primarily maybe parents who need that in their passing, who has concerns for the economic stability of their dependent. And at this time, I'd ask Senator Carroll to add his thoughts.
Thank you, Senator Webb. Senator Danny Carroll from the 2nd District. And I speak on this as a state retiree and also the parent of a special needs child. And my wife and I do have a trust set up for my daughter. And that if you don't know about those trusts, those are in place basically to protect that child. That's the only way that you can ensure that once you pass, that you can have that child will have assets to ensure that child's quality of life. There is no greater relief than to have those accounts set up and have that weight off of your shoulders, knowing that your kid's going to be taken care of should you pass away. And these trust funds allow for that child to still receive, in cases like waiver benefits. It does not affect any of those programs is in relation to them having income. So that's the importance of that. And as a retiree, if I were not married and being able to designate my retirement towards that trust, if I were in that situation, that would have been a huge relief, knowing that she would be taken care of. So I think it's a logical step. It protects the child with special needs, and it allows them to be cared for beyond the passage of a parent. And so I think it's a great thing that Senator Webb has done. I fully support it, and I think it's a benefit and a peace of mind for state employees under these situations.
We have Senator McDaniels wants to speak.
Thank you, Mr. Chairman. Thank you, Senators, both of you, for this. Mine is more of a technical thing. In reading through the bill, right, so the Special Needs Trust is there, and it does designate that it has to be a single beneficiary of the trust as part of this. But nowhere does it actually specify, that I can find, that the beneficiary has to be someone who otherwise is qualified to receive the pension of a deceased member. So, for example, the way I read it right now, I don't think this was the intent at all, but the way I read it is you could have a pensioner conceivably leave that pension to a special needs trust whose beneficiary is someone other than someone who otherwise would be eligible to receive the benefit being conferred. So you may tell me as a trust lawyer that no, I've misread this thing, but in my reading, it looks like you could conceivably end up with that scenario.
Let's see, we've tried to define.
In we can deal with it afterwards or in an amendment if necessary, or if I've just misread how these things work. But in my reading, that's what I became concerned about.
Respond to that, Tanner.
So, I think a lot of the purpose of the bill and a special needs trust is to benefit a certain individual.
Sure.
First party trusts are generally seen as sort of a retroactive measure. So if somebody was to become the benefit of a life insurance policy, you would designate the first party special needs trust as the beneficiary of those proceeds.
Right.
So I take this as a retroactive measure in the event that something were to happen, they designate their special needs child as the beneficiary of the retirement plan. The trust could then be designated as the beneficiary in exchange. So I just see it as a one-for-one. If you're a qualified beneficiary, instead of paying that out individually, you pay that to the trust. But I think, there's potential for clarity there.
Yeah, we'll look at that with, and if we need a floor amendment, we'll clarify that, because I think, and I'll speak with the drafter, because the definitions should be rigid. That's what we want in this, and I thought they were kind of adequate, but we will look at that again.
And I stand to have drafter. You guys are smarter at this than me, right? But I could just be missing it, but I want to make sure that we aren't opening that up in some regard.
Yeah.
That's another good point. And so I think, that is something definitely to consider. But another thing I just want to mention that is a common misconception. So with first-party special needs trusts, generally, they are subject to what we refer to in the business as Medicaid payback. So when the beneficiary passes away, it's not like those funds go to another designated beneficiary. At that person's death, whatever funds are left over or go back to the state to reimburse the
All right.
state for Medicaid benefits.
Thank you. So, Senator McDaniels, what Senator Webb will do is make sure that that language is succinct in what you want, so that it can't give to another beneficiary, that it'll go to what you intend to do.
Yes, we'll either get a better legal opinion on that in light of the language,
Or have a floor
and
amendment.
discuss that with you. But thank you.
Now, does this affect public pension? Is this funds that you were already going to get? It doesn't.
Yes.
Doesn't increase.
Yes,
it.
that's
Okay.
why PPLB.
All right. We have a
cleared it.
motion and a second. Madam Secretary, please call the roll.
Senator Rocky Adams, Senator Chambers Armstrong, Senator Elkins, Senator Heron, Senator Maiden, Senator Mays Bledsoe, Senator McDaniel,
Aye.
Senator Mills, Senator Rawlings, Senator Tishner, Chair Nemus.
Aye. Senate Bill 85 passes 8-0 with favorable expression. We expect it to do so on the floor. Thank you. That it? We are adjourned.